All right, let's get to that breaking news, everybody. We have got this. It's from the Supreme Court, where special counsel Jack Smith's request to immediately settle Donald Trump's immunity claim in the election interference probe, it has been denied, essentially shuttling that which Jack Smith wanted, the fast track, if you will, to decide presidential immunity. Donald Trump, of course, has asked the Supreme Court to take this case up as well. So there's a lot to get to right now because the interpretation of this could greatly sideline upcoming cases and potentially affect the 2024 election. Joining us now, we have NBC News Justice and Intelligence correspondent Ken Dilanian, and back with us, former U.S. Attorney and MSNBC legal analyst Barbara McQuade. Okay, let's go first to you, Barbara. What's your interpretation of this? How much does this set back Jack Smith?
Yeah, this is definitely a setback for Jack Smith, who had hoped to leapfrog the Court of Appeals and go straight to the Supreme Court. Instead, he will have to first litigate this matter in the D.C. Circuit Court of Appeals. Now, in the meantime, since he filed this request with the Supreme Court, the D.C. Circuit has said they would hear the question on an expedited basis. They have set oral argument in the case for January 9th. If they decide fairly quickly, then we could be back at the Supreme Court maybe within a month or so, if the court acts quickly. Or it could be that they take their time and we don't decide the case until June, in which case the trial will be delayed by that amount. So I think the March 4th trial date, either way you slice it, is in some trouble now. That doesn't mean it can't be tried before the election, but I think we're looking more at a summer trial instead of a spring trial.
Which potentially affects the election, Barbara. I mean, how long would a trial like this take?
I have assumed it would take about 2 months. There are, 5 different schemes here, each of which would probably take the government a week to try, give the defense a couple of weeks for their case, and then maybe a week for closing arguments and deliberations. So I think at the closest 8 weeks. But you're right. I mean, the primaries will have been settled likely by June. The conventions will be beginning in August. And so this would have to occur kind of simultaneously with a lot of campaign activity.
Okay, Ken, presidential immunity was, again, being bantered about on 2 tracks legally, right? And so with regard to the U.S. District Court of Appeals, January 9th being when that particular case goes and gets decided, or at least begins, with the oral arguments. Give me a sense of how this potentially affects that, if at all. Is that completely separate, or could there be influence in some way here?
Well, there's 2 arguments about immunity going on. One's in civil cases where Donald Trump is being sued, for example, by Capitol police officers over January 6th. The appeals court, the D.C. Circuit, has already ruled that he is not subject to presidential immunity because he was not acting as the president. And that was an important ruling because it interpreted the same conduct that the Court of Appeals is now going to have to interpret in the criminal context and potentially the Supreme Court. And what the judge found in that case, the judges found, is that the things that Donald Trump was doing to try to overturn the election, calling local officials, getting his lawyers to file lawsuits, a scheme to create false electors, none of that had anything to do with the role of president. The president of the United States does not have an official or statutory or constitutional role in state-by-state elections to elect a president. So what the judges said was he was acting as a candidate and as a politician and not as a president. So that may be relevant for both what the Court of Appeals has to decide here, and then ultimately we assume it's going to go to the Supreme Court. They may not have to get to the question of whether a sitting a president, now former president, can be charged for presidential acts while in office, because they may decide that what this was not presidential acts. And the way right now, there's a doctrine that the Supreme Court has already ruled that a president is immune from civil lawsuits while in office, but has never ruled on the question of whether a president can be prosecuted. The Justice Department does have a long-standing legal opinion that a president can't be indicted or prosecuted or tried while in office, Alex.
But then again, no president has actually been accused of doing the things of this particular one, which is why this is all so first time and really not tried in the courts before. Let me read something, and this was the argument that Jack Smith made. And he said, in asking the court on an expedited basis to do so, it presents a fundamental question at the heart of our democracy, that being whether a former president is absolutely immune from federal prosecution for crimes committed while in office. Barb, people were heralding this move by Jack Smith, this runaround, as we were calling it in just normal parlance, as being kind of brilliant. But as it turns out, it has not worked for him. Is it something that was a very risky move, or is it something that should have duly been tried because of the unprecedented nature of what we're dealing with here, big picture?
Oh, yeah, I think asking for that relief was absolutely appropriate. The court denied it, and he's in no worse situation than he would have been otherwise. And although this is a rare step to leapfrog a court of appeals, it's not unheard of. In the past 100 years, it's been done 45 times, and it's been done 25 times in the past 5 years. So it is something that gets done, especially in cases around presidential power or matters of significant public interest. So, good try. The court said no thanks. And I think one of the things that probably influenced the court's decision was the speed with which the Court of Appeals set oral argument. And I think that might not have happened if he had not filed that motion directly to the Supreme Court. So maybe in some ways he got a little bit of speed out of it anyway.